Welcome to the Genetic Alliance webinar today. I'm Ann Waldo, Senior Counsel at Genetic Alliance, and I am pleased to invite you to participate in our webinar. It's entitled The Myriad Gene Patent Case. What does it mean and why does it matter? This is a second in a series that we've put forward on the difficult and interesting issue of gene patenting. Our first webinar, which is available on our website, was on how and why genes are patentable. Both the slides and the lecture are available on our website, and we encourage you to take a look at that presentation. It explains why genes are patentable under current law and how the law has evolved since the seminal case of 1980. That presentation ends with a brief discussion of the case of Myriad, which is, of course, our subject today. The Myriad case. It's the Association of Molecular Pathologists et al. Versus the United States Patent and Trade Office and Myriad Genetics. The plaintiffs, who are represented by the ACLU, have been seeking a broad ban on the patenting of genetic material and genetic testing. The trial court has granted summary judgment in favor of the plaintiffs. We'll learn much more about that in a few moments. Now, Genetic Alliance is hosting this exploration of the hot issues in the case, this debate, if you will, because we are interested in educating the public and all of the stakeholders in this sphere on the tough issues in the case, and particularly with an eye toward moving the ball forward toward mutual understanding and possible resolution of some of the issues of the sharpest importance. Now, I want to be candid and transparent here. Genetic Alliance is not neutral with regard to the issues in the case. We filed an amicus curiae, a friend of the court brief, in opposition to the plaintiff's position. Now, we are asked many times why we filed that brief, so I want to be sure and mention that quickly. It was not because we were siding with any of the parties in the case. It was also not because we endorse or support any of the particular patent claims at issue in the case. If this had been standard patent litigation, we would never have entered. It's not even because of the law that is at stake in the case, in the sense that we generally do support the legal positions of the defendants, but that's also not why we entered the case. The reason we entered is that because we oppose the remedies that the plaintiffs are calling for in the case. We think that a broad and unprecedented abolition of gene-based patents would be highly disruptive, and it would undermine the medical progress that we want to see occur. We think that intellectual property protections for the risky and expensive translational research and development that is required to bring products to market we think those protections are an essential part of the legal and financial infrastructure that will ultimately help bring medical advances to the individuals and families that are waiting for them. There's a new statement posted on our website about the case and a piece of legislation covering similar issues as of today. Now, that said, we think that dialogue is absolutely crucial, and we all need to learn from each other. So here we are, ready to talk about all sides. Without further ado, I'd like to introduce our speakers. John Conley is of counsel of the law firm of Robinson, Bradshaw, Hinson in North Carolina. He's also a professor of law at the University of North Carolina Law School, specializing in intellectual property and biotechnology and civil procedure. I'll add, as I did before, that he's an anthropologist as well, which gives him a distinct curiosity about why human beings do what they do. In addition, we are fortunate to have Joshua Sarnoff, an associate professor at the DePaul University School of Law. He has worked on the brief on behalf of the American Medical Association that was filed on behalf of the plaintiffs. We also have Charles Collins Chase from the law firm of Finnegan, Henderson, Faribault, Garrett, and Dunner here in Washington, D.C. Charles has a Master of Engineering as well as a law degree, and he specializes in intellectual property. His firm wrote the brief on behalf of Genetic Alliance. We also expect to be joined midstream by Hans Sauer, who has another commitment but expects to be here when he can. He is the Associate General Counsel for Intellectual Property at Bio. All of these folks are speaking for themselves, not their employers or their clients. Without further ado, I'd like to turn attention to our speakers who will be illuminating the hot issues for us in the Myriad case.
Okay, Ann, thank you. This is John, and we were looking through the list of attendees, a very impressive list it is, And it seems to be predominantly a scientific audience with only a few lawyers. So before we go to Josh and Charles, it might be worthwhile for me to take just a couple of minutes and remind everybody of where we are in this case and what the basic holding is. This case is relatively unique in that it represents a frontal attack on gene patents. There have been a number of cases over the years that have nibbled around at the edges, but this one attacks them head on in this way. There is a doctrine under patent law called patentable subject matter. It's the first question in applying for a patent. Is it patentable subject matter? In other words, is it the kind of thing on which a patent can be granted, assuming that all the technical requirements for patentability are met? And this case holds uniquely that genes and a variety of methods associated with genes are not patentable subject matter. So under the holding of this case, the patent holder, Myriad Genetics, does not get to first base. Myriad has two general categories of claims. The first category is on genes themselves, and the judge in this case gave a couple of illustrative patent claims. Claims are the operative section of a patent. They define exactly what's patented and thus exactly what infringing conduct involves. On the gene patent side, product claims, claims on genes themselves, here's an illustrative claim that the court included. An isolated DNA coding for a BRCA1 polypeptide, said polypeptide having an amino acid sequence that is set out. So under one category of claims, this claim and others like it, Myriad got a patent on genes in isolation. That's the only modifier. The genes that code for the amino acid sequences that are specified. So it's the gene itself in isolation. The second category involves what are called method claims. The gene claim is a product claim. It's a claim on the gene itself. A method claim is a claim on a process or a way of doing something. An illustrative method claim that the court picks out, a method for detecting a germline alteration in a BRCA1 gene. Said alteration selected from a group and the method involving analyzing a sequence of the BRCA1 gene from a human sample or from cDNA and seeking to determine whether the germline alteration is a particular deletion. So a method for analyzing the BRCA1 gene. Other method claims involve methods for making comparisons between the sequence of the BRCA1 gene from a tumor with the sequence of the BRCA1 gene from a non-tumor sample from the same person. So those are the two general categories, genes themselves and analytic methods related to the genes. The court threw out both categories of claims. It said that the genes themselves were not patentable because they're insufficiently distinguishable from the naturally occurring version of those genes. The genes in isolation are not sufficiently distinct from the naturally occurring genes, therefore they violate what's called the product of nature doctrine. They are not patentable subject matter. The court threw out all the method claims as well on the general grounds that they are just abstract mental processes. There is a test that is the test, at least for the moment. It's called the machine or transformation test. And under that test, a method, an analytical method like this, has to be tied to a particular machine and or has to involve a transformation in the physical world. And the judge said that these method claims fail that test. Okay, just a word about legal procedure here. First point to remember is that this is a decision by a district court judge. This is the bottom level, the trial level of the federal system. And that means it's not binding on any other parties, other than those in this case. nor is it binding on any other court. So as a legal matter, it doesn't have broad effect today. It's being appealed to the Federal Circuit, which is an appellate court in Washington that hears all patent cases. When the Federal Circuit decides it, its opinion will be binding on all the courts in the federal system. Whether this case eventually goes to the Supreme Court, that'll be a couple of years down the road and hard to predict at this point. One final introductory point, and that is that there is another important case that's lurking in the background, behind the arras, like Polonius and Hamlet, and it's called Bielski. It is in the Supreme Court right now, and we could get a decision anytime between now and June. The case was argued last fall. Bielski involves what's called a business method patent. It's a commodities hedging scheme. So not on its face directly related to biotechnology, but depending on how the Supreme Court chooses to decide it, what they hold and how broad the language they use is, it could have a big effect on the method side of cases like Myriad. So with that background, let me ask our two panelists to make some opening statements. Josh, you want to start?
Sure, I'd be happy to. Thank you, John. It's a pleasure to be here with you and Charles and hopefully Hans soon. Thank you, Ann, and the Genetic Alliance for inviting me to be here. And I need to just issue a repeated disclaimer. I'm on the board of the Public Patent Foundation, which are also lawyers for the plaintiffs here. And as I did file, or helped to file, a brief for the American Medical Association and other medical groups in the case, I am speaking today solely in a personal capacity, not representing anyone else's views. The second is that I want to kind of emphasize something that John had focused on, which is the importance of this case. This is, in fact, the first square holding on whether gene sequences qualify as the kind of thing that can be patented. To be fair to the people who have acquired these patents, since the early 1900s, purified and isolated chemicals have been found to be the kind of thing that can be patented. But those are appellate decisions that may be in some tension with Supreme Court decisions, which was the premise of the district court's decision here. But in the subsequent lead up after an important Supreme Court case, Diamond versus Chakrabarty in 1980, the Supreme Court said that being a living thing is not a bar to patentability, and there they allowed a patent for a genetically modified organism. Since that time, and after some initial efforts by the Patent Office to seek to restrict the flow of patents on genetic sequences, patents have been registered for genetic sequences have been issued both in the United States and later around the world, subject to continuing debate. And the premise of this debate is that products of nature should not be privately owned. Most countries prohibit patents on products of nature, and the question that was raised by this case is again the one that John teed up, which is this isolated gene fragment or isolated gene sufficiently different from what is naturally occurring that we can call it a human invention for which patents should be potentially available. Similarly, the diagnostic and therapeutic methods are prohibited from being patented around the world, not so much on the product of nature idea, but they feel that medical technologies of this sort, where doctors would have to license the ability to perform certain methodologies, are simply bad public policy. It's a very different concern in part, but it's a widespread concern. And again, just to emphasize that this is an issue around which there is a lot of international discussion. The third, which again emphasizes why this is such an important case and why it can't be viewed solely from an innovation policy standpoint, is that many people view that evaluating one's own body is a human right, and ability to do mental analysis of certain things is, again, their right. And as, again, John had mentioned, that some of the claims addressed methods for analyzing people's own genetic sequences. And what's important, again, to understand there is that what the court ultimately found was, as Myriad had claimed those methods, they didn't require any predicate steps of actually performing genetic sequencing. They just required the mental step of analysis, which may make them different from other steps of a process, which include earlier activity, which has much more physical connotation. Finally, there's still a vigorous debate as to whether patenting genes and diagnostic methods is good for society, in particular whether it retards rather than promotes scientific research and product development. There was an important Supreme Court case that never happened in 2006 called Laboratory Corporation versus Metabolite. And the Supreme Court ultimately took the case and then said there are problems with the case because it had not been adequately set up by the lawyers below. So they ended up not ruling on the case. But there was a very unusual dissent from the decision to send it away, which articulated what was very interesting, which was the constitutional concerns. Not just that these kinds of patents aren't authorized by Congress under the statutory grant of power that Congress has received in the Constitution, but that there would be some constitutional limit to granting patents on things that would tend to retard rather than promote scientific research and development. Again, I'm just going to conclude here, but the premise of trying to go through this is to say these are not just innovation policy concerns, but social policy concerns that trigger deeply held moral beliefs. Those deeply held moral beliefs about what should and shouldn't be within the patent system, I think, are the impetus for having brought this case against Myriad in the first place. Myriad had become by that time what many considered the poster child for restrictive licensing practices. And consequently, it made, if you're going to bring a lawsuit, you clearly want to bring your lawsuit against an unsympathetic defendant. And Myriad was an unsympathetic defendant based on what they had done in restricting access to gene sequences that everyone in their lives are touched by, because both men and women develop breast cancer. Men do not develop ovarian cancer, which is also related to these sequences. So these are the kinds of concerns that animated the decision. It's why people have very strong feelings on both sides of the issues, wholly without regard to whether we need these patents to generate the kinds of investments and developments in technology that people would like to see.
Charles, you want to make some opening remarks?
Absolutely. First, I'd like to thank the Genetic Alliance and Ann Waldo for having me here today, and say that it's a pleasure to speak with John and Josh on these issues, which I personally find very interesting and think are very important for the patent system and innovation in the area of genetics. As Ann mentioned, I'm an attorney at the law firm of Finnegan, Henderson, Faribault, Garrett, and Dunner. And so, also in the spirit of full disclosure, I'm here today speaking in a personal capacity, not on behalf of any clients or the firm. But I also wanted to reiterate that I was involved in writing the amicus brief that Ann mentioned on behalf of the Genetic Alliance in this Myriad Genetics case, and also was part of the Finnegan team that represented the petitioners at the Supreme Court in the Bilski case that John mentioned. And so thought it would be important to outline the fact that I've been involved with those cases.
When you say the petitioner, who do you?
The side of Bilski, the patent applicant.
I'll just add, I was also involved in the Bilski briefing on behalf of law professors and the AARP.
Josh wrote an amicus brief in that case that I, of course, have read. So Finnegan is a large intellectual property law firm is essentially the bottom line, and that's my background, but I will try to present a balanced viewpoint today as well. I also want to say that we're here today to talk about the Myriad Genetics case, but I'm not really here to defend or criticize Myriad or Myriad's business practices or Myriad's patent claims per se. They're obviously very important to this case, but I think what we're talking about today is much bigger than anything limited to Myriad. And so we're going to be talking about these issues, and it's important to keep in mind that background of the fact that this goes beyond Myriad. So with that in mind, I wanted to outline quickly what I feel are some of the major issues and the main themes. And one of the most important things that I think to keep in mind is that we've heard a variety of terms already used today for what is actually being patented here. People say genes, sometimes contrasting that with genes in the body, or isolated DNA, or isolated DNA molecules. I think it's really important to keep terminology distinct and realize that what we're talking about with these patents are not genes exactly as they exist in the human body. The chemical structure of a gene, which is a chemical compound, as they are claimed in what we call gene patents, it's not the same as what you find in the body. So nobody is actually patenting your genes inside your body. And I think that's really important because that gets at some of the concern that people have about this issue of somebody's patenting something inside my body. That's chemically not the case. The things that are being patented are chemically different. They have distinctions based on how big they are, what their functions are, what they're useful for. And so the term that I like to use is isolated DNA molecules because I think that keeps clear that it is DNA, but it is a chemical compound that's been taken out of your body and is not the same as what's in your body. A second main point that I want to cover today is basically why this case should be important to people. Why do we care about the Myriad Genetics case, I think is a question that people may ask. And so we're focusing today on this case, the Myriad case, but the impacts of the decision and on related congressional legislation that's been proposed goes way beyond just the parties or just the BRCA patents or Myriad as a company. For example, the court's ruling, as Josh alluded to, may have a significant impact on the patentability of isolated and purified natural substances. And that's not just related to genetics. We're talking about not just DNA molecules, but proteins, vaccines, pharmaceutical products, agricultural chemicals, and a ton of other really important things that we use every day in society, including things that are very beneficial for patients for therapies. And so this ruling is extremely broad, and I think it's really important to keep that context in mind when we're talking about this case to remember why these issues are so important. And finally, I think that in general terms, when we're talking about what kind of patent system we want, people tend to think first about incentives for innovation. And that's kind of the end of what most people think about when we think about the patent system. But the patent system also has some other extremely important goals, one of which is disclosure. As part of getting a patent applicant is required to disclose in ample detail such information about his or her invention as to enable other people to understand what he's invented or she's invented, what the patent claims, what would be inside the scope of the patent versus outside the scope of the patent. And going back to the founders of the country, as far back as Thomas Jefferson, I think this is probably what was viewed as the single most important aspect of the patent system. The idea that we give people a limited right to use an invention, but that they put out for the public good the information about what they've actually invented. And so the idea of eliminating patents on genes is not simply the dichotomy between preventing people from monopolizing this stuff or enabling it to go into the public good. The idea of disclosure means that if we didn't have a patent system that rewarded innovation, we might find that people use things like trade secret to protect their innovations instead. And as a result, instead of getting more disclosure, we might actually get no disclosure at all. A classic example of something that's extremely valuable but no one really knows what it's made of, the formula for Coke. Everybody drinks Coke. No one really knows what's in there, and it's because Coke has maintained a trade secret on that. That could very easily happen with things like patents on genetic molecules or other chemical technologies if trade secret were the preferred mode for invention protection rather than patents. And so this is particularly important in the area of biotechnology and medicine because, indeed, we're not just focused on innovation or disclosure, but also on commercialization. Innovation for innovation's sake doesn't really do any patients any good. And even innovation and disclosure is not very useful to patients. What we want is to drive innovation on behalf of providing therapies to people. And I know that that's certainly in line with what my understanding is of the Genetic Alliance's mission is to deliver therapies to people. And so I think that our consortium of listeners will probably be interested in this issue. Fortunately, the patent system is excellent at encouraging people to commercialize their innovations. The idea of receiving a right to use a technology or sell an invention exclusively really pushes people to make investments in commercializing those technologies that they may not make without a patent. The idea is basically, you might do some basic research, but you'd be hard-pressed to find investors who will back your bringing the technology to market, and you'd certainly catch some flack from your shareholders if you just decided to develop things with no chance of a profit in the future. And so I think these are all really important things to keep in mind when we're talking about the patent system that we want to have in terms of driving innovation and driving therapies to people. The last thing I'll say is that there's quite a bit of back and forth in this case on different case law. But I want to make sure that people know that the case law out there, as I'll argue today, it does support patentability of products derived from nature when they're isolated and purified. And people will parse these cases in various ways to support various points, myself included. But there's a substantial body of case law out there that has patents being granted for isolated and purified natural products that are extremely important. Things like erythropoietin, EPO, which is important not only for patients with bone marrow transplants, but also for elite athletes.
Couldn't have the Tour de France without it.
Sometimes it seems that way. And in addition, you've got something like Factor VIII for hemophilia. And these are things that come from natural products. We view them as very valuable. And they're things I think that we would want to protect innovation for if that brings these products to market. Another example from the case law is the discovery of vitamin B12 as a useful product for treating anemia. Previously, you had to eat a pound of liver a day to treat anemia. And once you could isolate the vitamin B12 in a pill, you could take a pill instead. Obviously a very beneficial advantage for patients with that condition. And so my basic point today is that it's important to keep in mind that we're not patenting genes as they are in the body, that this kind of patent is supported by the case law, and that the innovation is not the end result, but rather the commercialization of products to drive those products to patients.
I suspect there are a number of things Josh would want to comment on there. Ann, you need to jump in here?
Just a quick word, if I may. I've been asked by an online participant to disclose the personal relationship that our CEO, Sharon Terry, has regarding gene patents, and I'm very happy to do so. After she learned that her children have the genetic condition PXE, she and her husband started working with the scientists who were actually involved in the area to isolate the gene that was responsible for the condition. They were successful in their scientific research and ended up collectively obtaining a patent on the isolated and purified PXE gene. PXE International, a nonprofit advocacy group that is also run by Sharon Terry, in addition to Genetic Alliance, is the licensing agent for the gene. We were also asked to disclose any financial relationships. I'm happy to do that. Sharon Terry receives no income from the patent. It is licensed by PXE International for a token fee to several quality test providers on the condition that all testing results must be added to a mutation database hosted by the NIH. The goal all along has been to ensure the broadest possible availability of the test, not only for treatment purposes, but also to encourage further research and making progress toward an actual treatment for the condition. Thanks.
Okay, thanks, Ann. Let me start with a couple of questions about the power of gene patents like those that are at issue in the Myriad case. Assume that I have a patent, like the Myriad patents, on a gene in isolation. What can I prevent other people from doing? For example, if I have a patent like the Myriad patent, can a hospital do its own testing for mutations on that gene, Charles, without my permission?
So to give a little bit of sort of background patent information, a patent gives people a right to exclude others from doing certain things. It's not strictly speaking...
Making, using, and selling.
Correct. It's not strictly speaking a monopoly, but rather a sort of set of exclusive rights to exclude other people from doing those things. So could a hospital use something that's covered by the patent without permission? No, they couldn't. You could do something that does not fall within the claims of the patent, and similarly, if somebody wants access to the patent, the system is designed to provide for licensing. So the patentee could derive an income from allowing other people to use that.
But I could also choose not to do that, if I were the patentee.
The patentee...
Might be shooting myself in the foot, but I could make that choice.
That's correct. And on that point, I think something actually that is brought up by what Ann just mentioned is important here. People tend to constrain, in this case, this discussion to the idea of Myriad's practices.
Right.
But in reality, there's a whole world of,
Sure.
of patents on these types of things out there, and Sharon Terry's example of a patent that is useful for treatment of PXE is an excellent example of kind of the other side of the coin of what actually happens in practice, which is that people do license these things. So, so yeah, I think that you could exclude somebody definitely from using your invention, but that there are certainly other ways to go about getting access to the technology.
And Josh, on the same theme, if I hold a patent like this one, can I put constraints on research? In other words, can I say to nonprofit academic researchers, you may not study this gene?
The answer, unfortunately, is yes. Under the current case law, we have what's called an experimental use exception, which the courts had developed, but they've construed it since roughly 1980 very, very narrowly. So even if you're a university-based researcher, since this furthers the commercial interests of your university to be able to do this kind of work, you're not immunized from the patent system simply for doing basic research. The other thing, going back to the question you posed to Charles, is that it's important to understand that it's, you know, although in most cases, because the court construed isolated DNA or isolated DNA molecule to be chemically different from what's actually in the body, excuse me, at the same time, it still prohibits people from removing their own genetic sequence and doing things with that, because to do so would be to create an isolated DNA molecule. That's precisely what the patent prohibits. Separate patents, by prohibiting the method of analyzing, say even if you could do that, and even if you then got the analysis of what your genetic sequence looks like, then you're prohibited from doing the analysis or comparison steps by the separate patents. So the product patents prohibit people not necessarily from having the genes in them, but from doing anything to analyze them or use them for diagnosis. And they also prohibit medical practitioners, not just the people who have them, from doing the same things. The one small piece of good news is that there's an exception from liability. It's still technically classified as infringement. Typically, you're not going to be able to sue the doctor directly and get a remedy. But interestingly enough, patients are not covered by that exception. So if they do it themselves, they could be sued, which then leads us back to Charles's basic point about, not everyone has bad licensing practices, which I think is an important thing, and it's really something to be highly encouraged, but doesn't really address the most basic question of, do we need these patents in the first place to get the kind of disclosure that Charles talks about, and to get the type of development of clinical testing or other activities. Again, one of the disappointing aspects of the court's decision is, although those issues were teed up, the court recites the allegation and then says, I'm just ruling on the law here. I don't need to make a decision about what is good policy, which I think was a smart thing for a judge to say, but is unsatisfying for those of us who want the answers. So I'll just read from a recent report by the NIH, which has both support and lack of support on both sides. What the NIH said was, taken together, this information suggests that scientists are motivated to conduct genetic research by reasons other than patents, suggesting that discoveries will be sought regardless of the availability of IP rights. They also noted that clinical tests are being developed in for all sorts of genetic sequences that aren't patented. But at the same time, they also said that patents do have a role and have a function in providing investments for this activity. So it really raises a complicated public policy issue about, do we need these patents to get the kinds of things we want, including disclosure, or don't we, for which we don't yet have any definitive statements.
Let me follow up on that point. I think of this as a goose that lays the golden egg kind of problem. We have a robust biotechnology industry in this country. It has developed under the pre-Myriad patent regime that favored patenting of genes, as Charles has described. if we were to upset that, would we be killing a goose? I haven't represented any parties in this case. I do work frequently with venture capitalists. Venture capitalists will say that they invest only in patents. That's a prerequisite before they'll talk to you. Do you have a patent? Will sufficient private money flow into biotechnology if we do away with Myriad-style patents? What do you think about that?
Well, I think the answer is a very complicated one. Let's start with some basic premises, which is that money certainly is currently flowing. Anytime you change a system, it will have effects. Similarly, it's not clear that venture capitalists are acting rationally when they're requiring patents, particularly if the premise is you're going to widely license and make these things available anyway. The real concern then is competitive sourcing rather than use. So again, you may have to distinguish between, do we need the patents for prohibiting research, competitive research? The answer is probably not. Do we need the patents for prohibiting competitive sales of products? The answer is, well, they certainly perform some role there now, but many companies will move into the market and develop these tests even without a patent that would provide them competitive exclusion from competing sales. So I don't know I assume the answer is it will certainly change things and practices consequently will change. It is not at all clear. And there's been some recent study based on entrepreneurs out of Berkeley, which suggests that in most cases, pharma and bio are more complicated, but in most cases, you really don't need patents. Entrepreneurs don't even think a patent is an important motivator for how they're going to develop their technologies. The one last thing I'll say, which also distinguishes these kinds of claims from some others, is that you don't currently need clinical trials to develop a diagnostic test. That means that we're not talking about recovering the $800 million investments that you need for a pharmaceutical drug. That makes a very different situation again, that even if there was some diminishment of investment capital that would lead to clinical tests by, so to speak, killing the goose, it's not clear you can't quickly provide chickens and have good eggs. Right?
Charles, what's your view on what would happen in the practical world of biotechnology if the Federal Circuit affirmed this decision, upheld it, and this became the law?
Well, I think I have about 5 points in response, and I'll try to go through them quickly.
Okay.
I think one important thing to remember is Josh mentioned some aspects of the Patent Act that provide for exceptions to infringement for various people. And so that's important on its own, but it also highlights the fact that in terms of some of the policy concerns that Josh mentioned, there's a very strong argument, and this is my opinion certainly, that it really is the job of Congress to be handling those policy concerns and modifying our laws in ways that reflect the ethics and sort of morality of society. It's not for the courts to apply the patent laws in a technology-specific way, because the Patent Act was not written as a technology-specific statute.
Well, as Josh pointed out, I mean, to be fair to the district judge here, the way he's written this opinion is, this is how I understand the law. He doesn't write the opinion as if we were trying to enforce some policy vision.
Well, that is true. However, a significant portion of the opinion is dedicated to the idea that going beyond the law, which establishes genes as chemical compounds, that the genes are actually also important in terms of informational content, which I think is squarely without the patent laws.
Well, let's come back to that one. That's an important
We'll save that point.
Yeah.
We'll save that
All
point
right.
for later. But in terms of policy concerns,
Yeah.
I think they're certainly
Okay.
embodied in the opinion, if not
Fair
expressed directly.
Fair enough.
I think another thing is that research is an important goal, but most of these studies that are coming out are finding that strictly speaking, basic research is not being impeded. And as an example, on the Myriad BRCA patents, there have been thousands of publications, including many reflecting research done here in the United States, that have issued since the time the Myriad patents came out. And indeed, even one of the plaintiffs on the case from Columbia University said, I think that these patents may indeed be important for innovation. And so in terms of the structure of balancing research and innovation in these areas, it's definitely not as simple as sort of saying we don't need the research, or we don't need the innovation that the patents provide, and it does harm the research. And I guess I'll just go to a third. I think you said what would be the result if these were gone. I think the simple answer is that you would see private investment drop. People will argue that there is substantial sourcing for public investment, but I think that's a very tricky way to set up a system of invention. And I've heard recently the NIH sort of warning people that essentially some of the grants that have been out there funding research in these areas will be drying up in the future because some of them are indeed linked to stimulus funds from the federal government. And so when you're working on a grant, as I think anybody who's worked on a grant will attest to, you don't ever probably feel sufficiently comfortable with your source of funding that you stop worrying about where the funding is coming from next. And that's also true for private companies, but in terms of private companies, that's what the patent provides, is an ability to go out and sell their invention by saying, we will make a profit on this, it will be worth your investment.
What the economists call a monopoly rent. You have the promise of the monopoly rent in the future that brings in investment capital in the formative stages.
Yeah, and I will admit that there are differing levels where this is necessary and where it's useful in terms of the different kinds of patents we're discussing. In terms of patents where there's no, for example, FDA requirements, as I think Josh mentioned, the incentive structure is certainly different. But I think nonetheless, the incentive to commercialize, which I think is really what gets therapies in the hands of people, is something that really does depend on patenting. So it's beyond just incentives for basic research.
Let me come back to this chemistry versus information point. I think Charles correctly.
Before you do, can I just make
Sure.
2 quick points. One is, one of the disappointing aspects of the decision, again, was that there were numerous allegations by the plaintiffs in regard to Myriad's patents in particular that even though they ultimately would settle, they had threatened people, they had filed lawsuits that actually did shut down research and shut down actual clinical practices of people who had been using their own tests. I'm less concerned about that than, as you say, the kind of the general point that this goes on. And it's really fascinating how people view this issue. There's a terrific study by a guy named John Walsh based in analyzing how people responded to the elimination of the experimental use exception. And what he found is that although universities were now kind of telling their scientists, you need to be careful, stay away from any patent trouble. And although cease and desist letters increased a little bit, overall, people were not really adversely affected. But the premise of why they were not adversely affected was that the scientists were rampantly infringing without worrying. Now, if the premise is no one's going to sue them, then you don't need the patents to do that. You may need the patents to prevent commercial sourcing, as they say, but you don't need the patents for that. And the consequence is, as soon as behaviors change, that could really dramatically impede scientific research and the development of testing. So that's why these issues are really not cut and dry. And why people view the exact same evidence as no cause for concern or truly alarming.
Okay, on this chemistry versus information point, as Charles points out, going back to the 1980s, we have the Patent Office granting patents on isolated genes, sometimes isolated purified genes, but on isolated genes. We have the courts, going back to the Amgen case in the late 80s and early 90s, at least acquiescing in these patents, if not ruling on them. And the premise is a chemical premise, that these genes are chemicals, these are chemical patents, and genes in isolation, with or without some kind of purification, are chemically different from the natural versions. That's been the state of the law until this case. This judge, as you point out, focuses less on the chemistry and more of the information-carrying content of the gene. And he says, well, maybe the chemistry is nominally different in isolation, but the only reason we're interested in genes is because of their information-carrying capacity, and that information is the same in the body and outside the body. Josh, who's got it right there? Should we focus on genes as chemicals, which supports patentability, or as the district judge does in Myriad, focus on them as information carriers?
I don't think you can ignore the information, but I think, and I'm guessing that both of you would agree, that the judge focused too much on the information aspects of the genetic sequences. So here we have to go back to the Supreme Court case law as distinct from the appeals court case law, which developed in the absence of the Supreme Court really weighing in. One important thing to remember is that the most relevant and most recent case in the Supreme Court was the Diamond versus Chakrabarty case. And what the court said there, that it had to, that the...
It's now 30 years old.
I understand. And they had to, that in order to be patentably distinct from a product of nature, what you had to have markedly different characteristics or function. Now, that focus on characteristics or function is not a focus specifically on the chemical makeup. It's really about function, right? So then you have to go back to even earlier case law, and the one I like the best is a case called Brogdex. And what Brogdex did was they had a piece of fruit, and they treated the fruit with borax, and it acted as a preservative. Now, there's no doubt that borax-treated fruit doesn't exist in nature. It is clearly chemically distinct as an
Thankfully.
enzyme. Right? Well, you might have better oranges off the tree. I don't know. But what the court said is this isn't a new thing, right? Even though it was technically new, because it clearly didn't exist. So that's really the question, is this enough of a change from its naturally occurring state to make it a new thing? And I think, again, under the appellate court precedents, the practice that developed of granting patents on gene sequences made sense. But I also think that it was in total contradiction to the Supreme Court cases, which said that you need more of a function. When the court in Myriad then comes along, it says precisely that. It says the defendants cite no Supreme Court cases for their position. The Supreme Court is supposed to be the highest level. Congress hasn't changed the law in a relevant way since the Supreme Court decisions before the 50 Act and the most relevant case after the 50 Act.
The 50 Act being the current Patent
50,
Act.
52 patent.
52 Patent Act.
Exactly.
Yeah.
Is the 1980 Chapter, and they said markedly different function, and I don't see it here. Now, you can argue about whether you think that the ability to manipulate the sequences outside the body is a markedly different function, but what the court essentially says is the whole premise of that function is its identity to the sequence in the human body itself. That's what makes this an important function. That hasn't changed. What you can now do is you can use it as a probe. That has changed. I don't think that's enough of a transformation.
Charles, you
that
got
would
it.
have been, I think, a much cleaner way
Yeah.
to have said it than saying information is different.
You have a brief rebuttal on that?
Yeah, well, you know, I have a different reading of a lot of this case law, but I think it might be useful just very quickly to kind of talk about, technically speaking, what the isolated DNA molecules we're discussing are actually like and sort of what they're used for. So an example of such a molecule would be what's called a complementary DNA or a cDNA. And what that is it's a copy of only the coding sequences of the gene. A gene codes for a protein. And the thing about a gene is that not all of the nucleotides that comprise that gene's sequence actually are important for coding for the protein. cDNA cuts out all the non-coding sections, puts together all the coding sections, and is isolated from the body. So it's, for example, you might have a gene of 1,000 nucleotides, and you might have a cDNA of a couple hundred. So you cut out a lot of stuff. The cDNA is used for a lot of different purposes. For example, it can be sequenced for diagnosis. It can be used in gene therapy. It can be copied and cloned into plasmids in something like a yeast or a bacteria in order to express a protein in a different species. It has a lot of really neat uses that we use all the time that are very distinct from, in my opinion, very distinct from what a gene from the body could be used for. And so I think that that is a different thing for all intents and purposes, and as such, as an isolated and natural product, the case law says it has to be isolated and purified, rendering it something new. I think that these things are chemically something new. I think they're functionally something new. And so when we're looking at these things, it's not like just taking a gene from over here and putting it over here and calling it an invention. It's functionally different in terms of what we're able to accomplish with the technology.
I want to make sure we have some time to discuss the methods patents, so let's do this now. There are a lot of people, including some people who just submitted some questions to us, who are skeptical that single gene patents are going to be that important in the future. They're talking about things like current generation and future generation gene sequencers, the importance of whole genome sequencing for medical purposes, multiplex testing. We can discuss in a few minutes whether we agree with that or not, but what about the methods claims? How significant are they to clinical practice and to research practice? Josh, what do you think about that?
Well, you've got to look at two things, I think, here. The first one is what is the scope of the claims themselves? And I'm going to go back to the product claims, then I'll go back to the method claims again. For the product claims, some of the sequences that are being claimed are not just the cDNA in isolation, but also fragments, small DNA fragments. And those fragments, at least in the court's opinion, the court said that even some of those fragments may exist in the body already in pseudogene form, or even if they don't, they clearly read on the naturally occurring stuff. So maybe those claims are problematic from that sense. But the key here is if the problem is you can't make or use, then it's not clear what activity you would engage in. If you do whole genome sequencing and you have generated a sequence, that's different from generating a isolated DNA molecule. So it may be that you can avoid those patents for purposes of whole gene sequencing if the only thing you do is spit out your entire genome and you haven't then made an isolated fragment claim. But you probably have, if you're able to separate and isolate the material from doing it in order to use that information, then it's going to be different. For the method claims, though, you've got this entire sequence. Now you're prohibited from analyzing it. That's where it would make a big difference, even to whole genome claims. And the more of the individual DNA sequence claim analysis or claim comparison issues that you get, the more licenses would then be needed to simply, perhaps not run the sequencer, but do anything with it.
I think perhaps the most important point here is that we're expecting a change in the law based on the Bilski case at any point.
Yeah.
And it's really important to keep in mind that anything we say today can be changed next Tuesday.
Well, why don't you spend a second on that? How specifically might Bilski affect methods claims like we have in Myriad?
Okay, well, so the Bilski case has nothing to do with biotechnology
Right.
or any of this stuff per se. But what it was a patent on a process. And a process is one of the 4 areas of statutory subject matter, and it's really the only one that's not sort of inherently linked to something physical. And so what the court and the Court of Appeals did prior to this case going to the Supreme Court was they established a test called the machine or transformation test that I think Josh mentioned that governs patentability of all processes. And so it's not just limited to...
We've been saying method, but method, process, more or less synonymous, right?
Yeah,
Okay.
so it governs patents for all processes, not just the ones that are at issue in Bilski. A narrow court decision from the Supreme Court, an opinion could maybe avoid some of the applicability to this field, but it's also possible that their opinion will definitely read on these issues. And so we're not really sure what to expect. I think we can probably expect a change of some sort from what the state of the law is now, but it's always difficult to predict, and I won't spend too much time predicting the ins and outs of Supreme Court practice. But
After Bilski, the Federal Circuit decided a diagnostic method case, very important case, very controversial case called Prometheus.
right.
What does that hold?
Well, they actually decided 2 cases, Klassen and Prometheus, and unfortunately Klassen was a 1-page opinion that said we affirm the rejection of these patent claims in light of the machine or transformation test in Bilski. So it doesn't really shed much light on the issue. But as you mentioned, Prometheus is a case that gave us a little more. It was relating to a method for optimizing therapeutic efficacy of a certain treatment. And basically what the claims included, claims of the patent, you would administer a drug to a patient and then you would determine the level of certain metabolites in the patient, and based on your reading of those levels, you would decide whether you ought to increase or decrease the amount of the drug that you administer in the future in order to make it as efficacious as possible. And as
Crohn's disease drug is the primary example given there, I think?
I think so, yeah. And basically, what the court said was that there are two aspects of the machine or transformation test, and the Prometheus case, they limited their analysis to the transformation problem. They said that there are two different transformations going on in that case. First, administering a drug is a transformation per se, because a drug doesn't simply pass through a human body without doing anything, or else we wouldn't be administering drugs. So the drug goes into the human body and it does something, and that's a transformation. And the court also said that the determining step was transformative, because you can't just look at a person and realize that they have certain levels of metabolites. You actually have to perform some sort of lab test, a blood sample or a tissue sample, in order to get the readings of those metabolites, and that was also a transformation for the purposes of the test set out in Bilski. Now, in the Myriad case, what the court said was that analyzing and comparing the BRCA gene sequences was not a transformation, and I think a really good question would be what verbs are going to count now and in the future as far as transformation. We know, determining counts, because they found that was inherently linked to a physical transformation in the human body, but analyzing and comparing is not, because you could do that without anything in the human body. And I'll point out that the claims in some of these BRCA patent claims, they actually refer specifically to taking stuff from a human sample. So it's not exactly written in the abstract where we would have no idea that this was limited to actually doing something physical with the human sample. But we reached a very different result in the district court than we saw from the federal circuit, which I found surprising.
So Bilski could upset Prometheus-style claims, Myriad method claims, and also Prometheus kind of claims.
Absolutely, and actually both the Klassen parties and the Prometheus parties filed petitions for writs of certiorari, which means that they've asked the Supreme Court to take their case. Those were conferenced months ago, which means the Supreme Court looked at the case and decided, in theory, whether they wanted to take it, but they have not issued decisions as to whether they'll take those cases.
So they haven't announced whether they're taking it or not taking it, cert granted or cert denied.
Which typically results in, when they decide Bilski, they'll do something called grant, vacate, and remand. They'll then say, we're accepting the case, we're getting rid of the lower court decision and sending it back to have the courts look at these again in light of this other decision that we're about to issue.
What do you think, Josh, of Prometheus kind of patents?
Well, it really goes back to, again, whether or not two important things are going on. Whether there's a requirement for physicality of some sort in the claim. And one thing that does distinguish many of the Myriad claims from the claims in Prometheus is the way the claim was structured was based on simply analysis of information. All of the physical steps were predicates, and the court read the claims as not requiring any physical steps other than thinking. That makes it different. Whether then the predicate steps are enough goes back to a slightly different question, which again, I think the Bilski case may give us some information about, and it goes to this prong of transformativeness that the Federal Circuit's decision had focused on and is being looked at in different ways by the different panel decisions in Klassen and in Prometheus. And that is that the categories for things that are excluded from the patent system are products of nature, laws of nature, and abstract ideas. And what Bilski involves is a method of hedging, which is not tied to any particular physical structure, but it does probably require some level of human interaction. And the question then is what is the abstract idea? And how much beyond that abstract idea then does the claim actually require? And is that transformative enough to pull this within the patent system? So one thing that might help people to understand what's kind of going on in these cases is it really depends on what you define as the invention versus whether you look at the claim itself and the category of what's going on. Let's say I invent some software, just an algorithm for doing certain things. And if I try to claim it as a written piece of paper, follow the steps, the court would dismiss that as not within the patent system. If I then reduce that into machine-readable format, the courts are kind of going both ways on this. But the premise is that when it's reduced to an article of manufacture, that article of manufacture falls within the categories of what could be patented. So the question is, if you read the claim addresses an article of manufacture having the defined software on it. But what's the invention? The invention isn't the article of manufacture, it's really the software. So if you look at the invention, the addition of these other physical things doesn't make a difference. It's just a way to get, arguably, a trick to get into the patent system versus, right? Well, they talk about lawyers' tricks and
Right.
right.
The Europeans say you can't patent a business method as such.
As such, and then the same question is what more do you need and where are we going to draw the lines and what's enough? So I think that Bilski will give us some feel for both what is meant by an abstract idea and what you have to add to it that is not, in the language of the Supreme Court cases, insignificant pre or post solution activity is simply having a lawyer add the fact that your software now is going to be claimed as embodied in a computer readable medium. Is that enough of a transformation from the abstract idea that the software embodies, leaving aside whether software is an abstract idea?
I want to get to some more of the listener questions, but I want to give the two of you an opportunity to comment on a couple of big picture questions. One is, if you were commissar of the Federal Circuit, speaking only for yourself, how would you decide the Myriad case on appeal? Charles.
I'm happy to field this one.
Well, you both will.
And although I would never presume to be as knowledgeable as any of the judges of the Federal Circuit, I think that the discomfort that people would have with patents in this area do not demand the solution that we've been provided in the Myriad case. I view it as kind of dealing with the headache by getting a lobotomy. Excising all gene patents from our patent system is really, in my opinion, at odds with the goals of the patent system, which is to provide certain incentives on a technology neutral basis. And
so what would you hold, given these facts and the law as it is?
I would say that isolation and purification of a natural product, it can give rise to patentability, and a gene as a chemical compound will be eligible for patents if it's isolated and purified, and that results in it being some new sort of product. That's for the product claims.
So these product claims, you would say these should stand up, you would reverse the district judge?
I would reverse the district judge's holding. I'll limit my statement to the fact that I would reverse the district judge's holding on the basis of precluding patents on all genes. There are different claims, and of course it's absolutely vital to look at the claim language as to whether we're making decisions one way or the other.
You use two modifiers there, isolated and purified. Many of the Myriad claims say just isolated. Did you intend any distinction there? Was that meaningful?
I mean, there may be a chemical distinction there, but it kind of depends on how you define the term purified. Certainly when you have it distilled to a cDNA, that's purified, but is it purified when it's separated from other genes in the body? I think it may be, but that's sort of another technical issue.
How about the method claims? What would you do with them?
Well, I'll say as a, again, fair disclosure, we took an opinion on this in the Bilski case on behalf of Bilski, and the argument that was so eloquently advocated by Mike Jakes at the Supreme Court, Mike Jakes is an attorney at our firm, was that really the way to limit this so we're not talking about abstract ideas is to ask whether the method has a practical application of the idea. And so things we might look at are whether there are actual steps that a person has to practice. And in the Bilski case, as Josh said, that is there. It's not simply doing something in the abstract with no human doing anything. And so what I would say is that under the practical application test that we've advocated in the Bilski case, a lot of these method claims that we're talking about, whether in Myriad, Prometheus, or Klassen, I think would be a little bit easier to get to the meat of what we're trying to prevent, which is a patent on an abstract idea. And it would avoid some of these distinctions between determining, analyzing, sequencing, isolating.
Under this rule, what would happen to the Myriad comparison claims, let's say, comparing the wild type and the mutated?
Well, I think that there definitely is a practical application there of a method, and that if the method claims, again, based on a claim-by-claim basis, obviously, if it's a sufficient practical application where we're saying that the patentee is limiting him or herself to such content as to not preclude everybody else from doing anything related to this idea, then we would grant a patent on that under the test I think the Supreme Court ought to put out in the Bilski case.
What does Judge Sarnoff say?
Well, I'm not there yet, and I'm not going to be presumptuous enough to say what I would do as a ruling on the bench, but I can say that I think, as we argued in our brief for the American Medical Association, that these particular claims do not survive under the Supreme Court's case law. So, like many other recent cases, I think that there's been a development of appellate law where the Supreme Court has stayed out of the area for a while, and on obviousness, what the Supreme Court did was to say the Federal Circuit had departed from its historic Supreme Court precedents, and I would think that the court is going to have to think very carefully about reaching a result that would conflict with those. In the Bilski decision by the Federal Circuit that's now up on appeal, the Federal Circuit was actually very careful and went through all of the Supreme Court case law to articulate the machine and transformation test, saying that this is exactly what the Supreme Court has told us, that's why we're imposing it. You can argue, and I think it had been forcefully argued by the Finnegan lawyers as well, that the Supreme Court said that this is not necessarily an exclusive test, and the Federal Circuit decision in Bilski says it's not an exclusive, it may be, this is the exclusive test for now, we're not saying it would, and it's hard to know what to make of a statement like that. So in regard to these specific claims, again, assuming that they don't reach the claim constructions to broaden them in some way, to apply to other things, the product claims dealing with either cDNA and not just cDNA, but other forms of isolated DNA should be found invalid under the Supreme Court precedents. And the district court was proper in applying the current law on method claims from the Bilski case to find that so long as those claims did not involve any predicate physical steps, that they should be invalidated. Now, it's conceivable that the Federal Circuit, if there is a challenge to the claim constructions, might reverse the claim constructions. Then you have a different question, potentially, which raises more Prometheus-like issues.
Well, we've just been joined by Hans Sauer, who is Associate General Counsel for Intellectual Property for Bio, and you walked in on some big picture questions. So I'll ask you one. I was going to put on the table 3 possible changes in our patent policy that I think would require congressional action. A couple of them come from a recently issued report by an advisory group to the Secretary of Health and Human Services. One would be a much broader research exception. The second would be a clinical testing exception, so that notwithstanding a Myriad-style patent, a hospital could perform its own tests on a patented gene. And the third would be a compulsory licensing regime. In this country right now, with the exception of some limited and never exercised federal government rights, we can't force anybody to give a license at all or to any particular party. Hans, how would you view policy changes like those?
Well, I guess, for any policy change, especially if they require legislation, I think we would always ask, has a strong enough case been established to warrant singling out particular technologies for special treatment under the patent laws? So generally, I think there's been resistance from patent lawyers, from the patent bar, and from industry to doing that. There's always a notion that the patent system should be uniform. It should have one set of laws.
No genetic exceptionalism.
No genetic exceptionalism like the one we see in the opinion as well, which I think is going to be an issue on appeal as well. So, the thought is, the problem that needs to be addressed, I think, will first need to be defined, and then we'll see if we can deal with it. To the extent, for example, that there is a concern, a legitimate concern, that genetic testing in the future is going to, probably already moves away from a single gene testing paradigm.
Okay, I mentioned that a few minutes ago. You want to elaborate on that point a little bit, where genetic testing in the future is going?
Oh, where we imagine that going? Yeah, when
Yeah.
I talk to like BIOS member companies, there is a sense that there's probably a standard of care that is developing that will require for any given disorder in the future the testing not of one gene or two genes, but the testing of a panel of a dozen or 50 or 100 genes. And to take that one step further, eventually we will be able to provide whole genome sequencing services for $1,000, which is much less than the cost of some single gene test today.
Now, do those technological developments make a Myriad-style single gene patent more or less powerful?
I think, you know, Myriad's, or the reaction of a company like Myriad, and again, I can't speak for them because they're not even a biomember. I think the reaction will depend on whether, at the time that situation arrives, where we do whole genome sequencing for relatively little money, or multiplex testing routinely for large numbers of disorders. At that point, we first ask ourselves are there even many companies still in the business of testing single genes? Myriad's patents, for example, will expire in 4 or 5 years. There is not a large number of companies in the business of providing single gene testing to begin with. There are not many companies that operate under this business model. So to the extent there are still companies operating like that, when we start doing whole genome sequencing, I think the company's question will be, does this work interfere with the remaining life that accrues to my business model or not? Does this interfere with my business? Does it compete with me? At this point in time, what we see companies like 23andMe and a few nascent companies who want to get into this sector and whose development I think we want to foster as an industry, because they too are part of the biotechnology industry. What we're seeing right now is that these companies offer their services with great disclaimers, because it's currently not done to CLIA standards. It's not done to the standards of a true genetic diagnostic clinical test. It's not done for the purpose of diagnosing a disease, and the companies are careful to point out that the results shouldn't be relied on for medical decisions. So that's today, and probably for the coming couple of years. I think in that situation, a genetic testing company would probably say that's not the kind of activity that interferes with my business, because anybody who would get a personal genome and take that to their doctor and identify something that they're worried about would probably not make a medical decision based on that. They would have a proper clinical test done in follow-up. So it's actually maybe even good for the patentee, because it drives additional tests. So, but that's for now. I think, a couple of years later, we may get to the point where these tests can actually be done on a whole genome basis, under CLIA certified conditions, to the proper quality standards that actually do exceed to the level that's necessary for diagnosing a disease. I think when we get to that point,
If I do
yeah.
multiplex testing, as you described it, and/or whole genome sequencing, do I likely violate the Myriad patent?
That's actually a question, right? Myriad was quick to point out in this litigation that the isolated and purified DNA claim means just that, isolated from the rest of chromosome 17, so you go like chromosome 17, SNP. BRCA sequence, SNP, rest of the long arm of chromosome 17. I think, as we understand whole genome sequencing to progress in the future, they will have machines run through that, and there will be no isolated SNP claim.
What do you think about that,
Well, again, remember, some of the claims were to 15 base pair sequences, which clearly are going to appear as you run your entire gene sequence. The difference is again, if the claims are not limited to the sequence information, but to actual isolated molecules, then again, it's not clear that doing the whole genome sequence will generate the isolated molecules which have the 15 base pair sequences. It's not clear, again, I don't know enough about the mechanics of whole gene sequences. Not clear you actually isolate anything in running the entire sequence. The converse, though, is the method claims clearly would apply when you're trying to analyze that information, because if you've got the 15 base pairs, you're trying to compare it, then they would apply.
That is true. If the claims are properly construed,
Right.
to say, the analysis is done on whatever, an isolated the analysis is done without actually the mechanical and analytical predicate laboratory work, if you will. So you identify a problem that's inherent in the drafting of all diagnostic claims, and that is you always want to draft them so, that's what we've been taught as patent attorneys, that any one given person can infringe the whole claim. So if you were to draft a claim that says first you must pull a sample, then you must analyze it in a machine, then somebody must read the sample and make a decision on it, that claim is performed by 3 different people. And it creates problems for the ability to establish infringement because no one party infringes the whole claim. It's done by 3 people, and each does a step. Not a good claim to try and enforce. So that's why patent attorneys are pressed to draft claims in ways that take away these extra steps and make the claim more problematic in the sense that it is, at some point it becomes free-floating, disembodied, and happens, almost exclusively on paper, which is what Judge Sweet construed the method claims here to mean. He said, there's no laboratory analysis required. This can be done just by looking at the results. If that claim construction holds in the Federal Circuit, I think if the Federal Circuit agrees that that's what the claims mean, then the Federal Circuit will probably say they're insufficient. More is required. You got to tie it more to the laboratory.
Charles, a couple of practical patent law application questions for you.
Sure.
Suppose we've got a claim like Myriad. It's a claim on a single gene, and we've also got these method claims. Can I send a sample? I'm a doctor. Can I send a sample to a country where this patent is not in force? Patents are, with some exceptions, country by country. Can I send a sample out to a country where the patent is not in force, have the testing done there, and have the results sent back to me in the United States? Is that an infringement of U.S. patent law?
Well, the first thing I'll say is that it's important to keep in mind the fact that there is the medical practitioner's exemption for infringement, which would seem to cover the activity that you're talking about in terms of exempting that medical practitioner if that person is doing it for the purpose of treatment. They would not be liable for infringement.
The individual doctor.
Correct. In terms of sending it out of the country, I mean, certainly people do play around with the patent laws of different countries to attempt to avoid infringement liability, but I guess it would depend on what was actually being done where. For example, people also historically have liked to use DNA molecules to create proteins. The proteins are old and not patented, so they do the patented part of the process outside the United States and import the unpatented proteins into the United States. But there is a section of the Patent Act that explicitly says that will actually be an act of infringement.
Right, I know that, but
So-
just with information.
Performing the process outside the United States,
And bringing only the
Bringing only
information back
information
as the
back in.
result of the process. I think there's a case, the housing case
Yeah.
Exactly.
I was going to say, I think
Yeah.
the importation of the information, they
wouldn't qualify.
Would not qualify.
Would not qualify, in other words, would not be infringing.
Would not be infringing. But if you made the isolated sequence here to ship it over, that
Right,
would be
yes,
infringing.
yeah. And let me also ask you, Charles, to follow up on a point that Hans made about where things are going. As a patent practitioner, what's going on now with single gene patenting? I mean, we see a lot of apocalyptic claims about percentages of the genome that are patented. Is this still a going concern, the patenting of individual genes? Has this slowed down? What do you see?
Well, I have to confess that I actually don't do any patent prosecution on gene sequences or isolated DNA molecules. I do primarily litigation, and so we get these cases once they've already been through the ringer of applying to the Patent and Trademark Office for a patent. So I'm probably not the best qualified person to address that question in terms of what the people are doing in terms of patent prosecution.
Okay,
I
Either-
might have let me see, the Georgetown University, I think, it was Georgetown that maintains a database which isn't totally updated on gene patents that have been issuing, and I think their findings were, and the data are current as of 2005 or 2006, that there was an uptick in the number of gene patents in the late 90s, spilling over in the early 2000s, and that has since leveled off at a relatively stable level that's that's going back to the mid-90s. I don't know the rates, but new gene patents are being procured. Now, they're not all human. And in fact, anecdotally, I'm told that with the publication of the Human Genome Project, and with so much being known about the human genome specifically, it is getting harder for a number of reasons to procure patents on human genes. Now, there's still a lot to be discovered. New mutations are being found, and so on. So that is still going on, but I think the area that I hear about most currently is in the agricultural area, where there are still many genomes that are waiting to be unraveled. Many genomes whose discovery doesn't receive as much public funding as the human genome did. So, if you have companies that are interested in the pistachio genome, it's hard to get public
I would
funding
be
for that
interested in
kind of thing.
So just one other piece, there's been some recent work by Bob Cook-Deegan and others which have shown that in publicly available database information, many of the things claimed by Myriad in this case had already been disclosed in a way that should have prevented the patents from ever issuing
Right.
as well. So I think Hans's point about the fact that the more information is out there, the more likely it is that people will recognize that they can't now patent some of the sequences. The converse, of course, is that for those sequences that people can find, they may be much less likely to publish immediately until they then assess patentability, so there may be a delay in public access.
You raise another whole set of points here. We've been focused today, it's our topic on the Myriad case, which is a patentable subject matter case. Is this the kind of thing that can be covered by a patent? But that's only one of many requirements to getting a patent. And we've had a lot of action on the obviousness standard. This is a sometimes subjective standard. You can't get a patent on something which is a merely obvious advance over the prior art. That is the sum of public knowledge at the time you invented your thing. It had been the law for some time that the fact that gene sequencing techniques were well known, and you also happen to know a fair amount about why a particular gene was an interesting target, putting those things together did not render a particular gene obvious. But that law's changed. We have a case called Kubin, K-U-B-I-N, and it's made it, I think, substantially easier to, at least going forward, to reject patents on obviousness grounds. Charles, you want to comment on that, perhaps?
Well, I think it's an important point you raise, and I'd say before even answering that, I think it's really crucial to remember that what we're proposing here in terms of a solution is banning gene patents. That's essentially what people are talking about. And
Myriad is a broad brush decision.
yeah,
as of now.
exactly.
Yes.
And so this goes to what I mentioned, one of my first points is the scope of this decision. In point of fact, a patent application is judged on a variety of standards, and obviousness is one that tends to kick out a lot of patents. It's a very fine screen compared to the rather broad and intentionally broad Section 101 for patent eligibility. I would say that, for example, Josh has raised a number of times these shorter sequences of, say, 15 nucleotides. I think that things like this are the kind of thing that will potentially be more likely to be kicked out under an obviousness standard in light of the current
Yeah,
case
just to
law.
put a technical spin on it, to me, those 15 nucleotide sequence patents are nuts. But anyway, go ahead.
Maybe not for me to judge, but there are other routes, and so it's important to remember that just because something passes 101 doesn't mean it gets a patent. It just means that in these four really broad categories of things that we give patents for, it's not outside of that. We will proceed to analyze it under these more rigorous sections to determine if they'll meet the patent requirements, and 103 is a really important one for kicking out things that people think, well, that's
Josh, can we
not too
just
important.
take a deep breath here and stop worrying about Myriad and assume that the obviousness requirement is going to exercise adequate controls on gene patents?
I think the answer is no, in part because it becomes costly and more difficult to do this kind of case-by-case determination on what is and isn't obvious when we don't have a clear standard. One really interesting piece about the Bilski case is that in the historic case law, which was reiterated as late as the 1978 Fluke decision, is this unusual statement, which has longstanding support in U.S. law, not necessarily in other countries' law, that the scientific discovery is treated as if it was already known when you make your application. The implications for obviousness law, as well as for patentable subject matter law, is really significant, because if the discovery of the gene itself is already known, then actually getting the sequence through a known analyzer technique, there's no real inventor there at all, but certainly would be an obvious thing to do. So it may be that if the court really focuses on that language, it would take care of the problem. And I tried in my brief to the Supreme Court to explain the relationship between the patentable subject matter doctrine and the obviousness issue precisely in part on that basis. The second thing is it emphasizes the non-uniformity issue. And although it's true that historically patent law has been non-uniform, that has been breaking down in various ways. There are special provisions, we've mentioned a couple of them, which are the 103B provision, which was highlighted in the Genetics Alliance brief, on a special rule for biotechnology process obviousness to address this issue of known processes applied to new things. There's the business method patent exception, there's the doctor's exception. These are all exceptional provisions in the patent law, special things for special areas. What we haven't yet seen is anything that looks like the copyright law, which has lots of different rules for lots of different industries, including the most visible one being sound recordings are treated differently from other types of creativity.
Cable TV, you got libraries.
Exactly, lots of different rules for lots. And so that raises a question, should we go to a more non-uniform system? There are some costs to non-uniformity, more lawyers, because you got to understand what's involved, and more public knowledge to understand what goes on. But generally, non-uniformity is thought to be a good thing where the costs of administration are not too high and when there isn't significant what they call rent-seeking problem, where it doesn't lead to everyone lobbying Congress for lots of different exceptions.
Let me, we've got about two or
Yep.
3 minutes left. Let me take a listener question here and ask you for a 1 minute, each of you for a 1 minute comment on this. And the question is very simple. What do you think, if anything, Congress should do about the problems posed by the Myriad case? Hans?
I think the case is being addressed by the courts as we speak. I think we should let this case play out, and Congress should then see what it needs to do. I think it's a bad idea to interfere in something that the courts will grapple with and work on.
So you don't favor Congress jumping in now with a research exception or a clinical exception or compulsory licensing?
Well, Congress rushing in breathlessly to deal with a problem that's already under consideration.
That's always
I don't
scary.
know.
What do you think, Charles?
I would say that, yeah, I think it's going to be important to let the case go forward and see what happens in the future. I will add that I think that if we wanted to do some of these things more tailored to policy, that maybe Congress may be a more appropriate venue for doing something.
You got anything in particular in mind that they ought to be thinking about at this point?
Well, I don't have anything that I think they should be thinking about, but I know that there are people who are thinking about essentially legislation it's going to be introduced, as I've heard by Congressman Becerra, that will potentially be even broader than the Myriad case, and I think that would be tremendously detrimental.
Congressman
to the
Becerra
industry.
has in the past introduced very broad anti-gene patent litigation.
And the important point about that is that it may have the effect of as the Myriad decision may, preventing patents not just on isolated DNA sequences, but also on all sorts of natural products that are of tremendous value and have represented a great deal of innovation.
Josh, you got any prescription for Congress looking ahead?
I think two things. The first one, you mentioned a research exception, which I think can be justified solely on its own merits, and Congress should do without regard to this particular issue, but would take some of the pressure off, I think, some of the concerns that people have if we're not going to prevent people from doing further research or developing other things with the patented invention. It's good for everyone. And if people are already forbearing from that, then they don't need that kind of protection anyway. The more interesting question really goes to whether Congress should weigh in on the issue of the scope of gene patenting or the scope of patentable subject matter at all. And here you have an imbalance, because if Congress restricts the scope of patenting from where we think the law is, you may get takings concerns. If they expand the scope of patentable subject matter, you may get constitutional concerns, which again were argued in the case, but the court studiously avoided them.
Constitutional because we have patent law because the Constitution authorizes Congress to create patent law.
To create patent laws, and the argument is that it's a limited grant of authority subject to certain restrictions.
Promote the progress of science and the useful arts.
That was the first limitation that was focused on in the LabCorp case as a utilitarian matter. In some areas, patents do more harm than good. They don't promote progress.
So they wouldn't progress. They inhibit progress.
And the question is, and the argument is that prohibits Congress from legislating so broadly. There are other limitations, both the useful arts, which is the subject of the Bilski argument in part, that you need technology. Congress is only authorized to issue patents for what we consider technology. And then there's inventors for their inventions, which again was more the focus of the brief that I filed, which argues that historically we've understood those to be distinct from discoveries in various ways. So there are different issues if Congress gets involved to expand versus if Congress gets involved to contract. The last thing is the courts don't have those issues for two reasons. First, they're the final arbiters of the Constitution, and second, to the extent that they constrict the law, saying that this is what the law is and has been, rather than changing the law, there are no takings concerns either. So I think it actually is better to see what the courts do first, then we'll see what Congress does after.
And we have a request for a clarification of a more technical point that I think I may have made earlier. Maybe, Charles, you can help us on this one. We have this district court decision. It holds that these patents are invalid. So, first question, what does that mean exactly, a district court decision holding these patents invalid? What does it mean for the parties in this case? Can all these medical research plaintiffs be out there today using these patents as they see fit?
Well,
using these genes as they see fit.
so the first point is that the case was representative claims from these patents, and so we have, and they have, Myriad has other patents on these technologies.
Right.
So in terms of actual use, I think it's not so clear that knocking out claims of these patents will have an effect, and I think certainly Myriad has stated that they don't feel that this case will immediately have a
But these
detrimental
claims,
effect.
these particular claims, they are invalid as of today?
Under the district court's ruling, yes, they are. And important to keep in mind that a district court ruling is not going to be binding on anybody else around the country like a ruling would be from the Court of Appeals for the Federal Circuit.
Okay, so that was the follow-up question. That is, suppose that I am a researcher and I want to use a gene that's covered by a patent that to me and my university counsel looks just like the Myriad patent. Can I go out and do that under this decision? Somebody else's patent. It looks just like
No, I
this
mean,
one.
the decision's limited to the
Okay.
claims here.
It affects no other company's patents.
No, I mean, it's a ruling on the patents that are at issue in the case, and indeed the claims that are at issue in the case. Federal Circuit ruling would be precedential, by which we mean would govern decisions in future litigations, but indeed even that would have an effect on the future adjudication of patents, but would not immediately invalidate all sorts of patents.
We also have a question about the differences between isolated and purified DNA as claimed in patents and the DNA in human cells. The listener asked, isn't the point of a diagnostic test the fact that these two forms of DNA are identical? You got a comment on that, Hans?
Well, they are different as a matter of chemistry. Scientists are quick to point out that difference is immaterial because what really matters is the genetic sequence that's embodied in the gene or in the synthetic molecule in the lab. Doesn't make a difference to the scientist. In fact, it's necessary to do a diagnostic test because, if the genetic sequence weren't the same as in the gene or closely related to it, the test wouldn't work. So, that makes sense. In that sense, though, a lot of biotech inventions are exactly the same way. Medicines we give today to treat depression mimic the function of natural brain serotonin. Other medicines we give mimic something that happens in the body. The idea is always that you do something that's related to, analogous, identical to what happens in the body, and you do it with artificial means. I think the relatedness of what's going on in nature and what you're trying to mimic in the lab or with your product, the fact that that's the same shouldn't be a determining factor. But yes, the whole point is.
I guess I'll add one technical point. I don't want to get too technical, but I mentioned cDNA molecules and how they cut out certain parts of the gene as it exists in the body.
Non-coding region.
Non-coding regions called introns. And while introns don't code for a protein, they do have an effect in some cases on the expression of the gene. So for example, an intron may have the effect of determining how much of a protein is made. And also on the point of cDNA, there are different chemical sort of nuances that we haven't talked about today, but that are important, again, for expression. One of which is that, unlike genes in the body, cDNAs will not be what's called methylated, and we don't need to get into the chemistry of it, but basically there are some differences that are not perceived maybe by most people, but that functionally and chemically are going to be significant differences in how the genes express in the body versus how the cDNA or an isolated DNA molecule operates in the lab.
And Josh, you had made a point earlier about clinical trials are not required for diagnostic tests, which minimize the need for the monopoly income that a patent would provide. And a listener comments, not so for IVDs and some other things. Do you want to comment on this question?
Sure. Again, and it's not that biologics can't be used as drugs either. It's a big developing market. So what I'm trying to say is that for some things you may need significant amounts of investment, for others you don't. It's clear that for some of the clinical areas where there are no large-scale clinical trials needed, those have been developed in the absence of patenting, and this really is a question of how we decide to fund things. The most interesting questions being asked right now actually go to whether or not we want to find alternatives to the patent system entirely to fund drug development, or again, if IVD diagnostics are subject, it's news to me, but if they are subject to clinical trials also, those are very big ticket items with large social benefits, and many people are suggesting that it would be socially a better thing to go to a prize system, as an example, or to simply have publicly funded clinical trials to do it that way. These are industrial policy decisions at the bottom line. So again, it's fully understandable that those who are already engaged in the private sector would want to continue the business model. It's not clear that it's the best social way to go about things.
Yeah, there is a sense, if I may say, I've heard that not everybody has great faith in the government being able to manage and do all these things.
I've heard that.
I guess, this country, as of next year, will have lost its ability to send men into space, but maybe the government is going to do a better job on biotech if we let it. For now, we'll see.
Yeah. One more question here. Charles, you talked earlier about trade secrets, and you mentioned the Coke formula, which is not patented but has been protected, I think, since the 19th century as a trade secret. To protect something as a trade secret, you keep it secret. And as with Coke, you make it and you sell it in such a way that you don't give away that formula. And there's been a lot of discussion. There's discussion in an old Supreme Court case about the patent system being better for the country than the widespread use of trade secrets. Because both a patent and a trade secret program can get an invention out into the marketplace, give the public the benefit. But in order to get a patent, you pay this price of disclosure. If, I encourage listeners, go to uspto.gov and read some random patents. And there's all this, read the Myriad patents, there's all this incredible level of disclosure. So one argument for robust patents in biotechnology is, well, otherwise we'd have companies exploiting biotechnology via trade secrets. We wouldn't get the benefit of disclosure. We wouldn't be informing the next generation. But my question to you is, well, is that a realistic concern? Could trade secrets play any role in biotechnology? Doesn't all this stuff have to be disclosed to the FDA and whatever?
Well, so I think that one aspect of this is that there's sort of a balance between upfront costs for commercializing and disclosure. And indeed, the sort of concerns about disclosure through the patent system may decrease somewhat when we're talking about things that are submitted to the FDA, but then you sort of get a commensurate increase in the upfront commercialization costs, which drives the benefit of the patent up in terms of protecting investment in commercializing and marketing. But I guess in terms of whether things could be kept trade secreted, I would say that maybe the more important question is how much would we be deprived of the value of having the information sooner, and what would be the social costs, both in terms of time and money, of having people continue to reinvent the wheel time and time again. Sure, we could probably figure out exactly what somebody's done and maybe disclose to the FDA, but it might waste substantial time and money in doing so, and we wouldn't be able to build on the back of that invention from the start.
So if we're talking about cola, everybody else is always reinventing the wheel. Not even
Well,
Coke can improve on Coke.
I don't know the direct applicability of that analogy to biotech, but kind of the idea that, you know, if people really want to get access to a product, they may be able to figure it out or figure out some reasonable approximation. But the amount of effort that they would expend in doing so is effort that they could have spent instead looking at a better way to get the same result, or a different technology that goes even beyond what would be disclosed in the patent. And I think that happened in the Myriad case, where their original patent applications drove some of the marketing that companies did in order to be able to be on the market so fast with similar technologies.
Josh, if we,
Can I
yeah, go ahead.
respond?
Yeah.
Two things. First, I don't think that trade secrets are a viable alternative here, because a trade secret only protects you from people discovering your trade secret by improper means.
Right.
But you can reverse engineer things perfectly legally, and I think in many cases, once you've isolated and purified the sequence, if you're putting this out as a product, it would be relatively easy to identify what it is, and then come up with the chemistry to make it yourself. So it's not clear that people can really look to trade secrets for the kind of protection they might want. Conversely, it really raises the question again, are there already adequate incentives to disclose things that have significant public benefit, where federal money is often going into all of the R&D in the first instance? The patents are then developed because of the Bayh-Dole Act structure of the federal government granting licenses to encourage, or granting patent rights to people funded by federal money.
Just make sure everybody's got Bayh-Dole legislation in the 80s.
Right.
Birch by Bob Dole, and it says that entities like universities that receive federal grant money not only can take out patents, are encouraged to take out patents,
Exactly.
and then to grant licenses.
Right. So again, there are reasons why these individuals are patenting, but there may be adequate incentives to disclose even without the patent incentive. And as we've discussed, in many cases, the patents then actually, for at least temporarily, deter or slow down the disclosure, because you have to make sure that you filed your applications and cleared things. So all of this points back to the idea that, you know, that may not be as true for some not so high profile areas of public health concern. And if that's not true, then the question is, what's the best way to fund the development in that? And if they're not that big public health concern, they're also, in many cases, not necessarily that big a commercial market, and they therefore may not have development of these things anyway, even in the private sector with patents.
Well, we've got to wrap up. Let me ask each of you to give us a last word. A few seconds. Final comment?
A few seconds. Again, I think, repeated calls to maybe give, the government a greater role in funding basic research. Combined with the notion that we don't want to make patent protection available for these kinds of basic genomic inventions, whether they arise in the human space or the plant space or the microbial space, to our mind, sends the wrong signal. If we take these patents away, the signal is private investment in basic research is unwelcome in this country. I don't think overall we're here. And as we speak, there is some creature growing under a tree stump in Amazonia that carries in its genome the answer to bladder cancer. And somebody goes and identifies that critter and fishes out of its 10,000 genes the one that has the answer, and isolates and purifies that into a lab-generated DNA molecule that has great potential commercial value. We just don't see, why that should not be worthy of protection. We don't see why somebody should be told, you can't get a patent. You only discovered something that was always there and that was, in the storehouse for all men to freely use.
Charles?
Well, I think I've emphasized enough the kind of chemical differences between these things that are actually being patented, but I guess I'll just reiterate what I think is one of the main takeaways for people today, which is that this is not just a discussion about Myriad Genetics or a discussion about the patents owned and being challenged here by Myriad Genetics, but rather a ruling that has potentially tremendous breadth and may impede innovation in a variety of areas related to natural products. And so I would encourage everybody listening to sort of broaden their view of this case as not just the Myriad patents, the BRCA patents, but think about whether the solutions that we've seen in this case or that are being proposed sometimes in Congress are the appropriate ones for this whole host of really useful products and innovation, and think about whether really it's appropriately tailored to just ban gene patents when really we're talking about this whole enormous area of innovation being done by a lot of private companies and public entities alike.
And Josh?
I'll just conclude with the idea that it's not a concern so much over private investment in these areas as exclusive ownership. That's really at the heart of these issues. And there are lots of other ways that investment can be made. And in many cases, we don't require exclusive ownership in order to incentivize people to enter the market. And again, the economic studies show that with the exception of areas where you really need to recover large costs and there are low marginal costs of production, most businesses don't really look to the patent system to protect their innovations. So, in this case, I totally agree with Charles that it's not just about Myriad, it's about whether we really want to lock up this information, lock up these kinds of discoveries within the hands of a particular party and subject it to the licensing patterns that they choose to use.
And my last comment will be about the three bears. Remember the three bears? Is it too hot, too cold, or is it just right? I think patent law and policy is very much about getting it just right. The Constitution, the framers of the Constitution thought we should have patents to promote the progress of science and the useful arts. That's the language of the Constitution. So the question people who practice patent law, decide patent cases, decide on a day-to-day basis is, how much protection do we need to promote progress in science and the useful arts? We certainly want to have enough to do that, but we don't want to go too far to impede it. And it seems to me the issues we've been discussing today are right on the border, too hot, too cold, or just right. And I think the key to forming an intelligent viewpoint about these issues is deciding how much is just right.